Hi, I'm Lisa Boogaard from Boogaard Attorneys, and today I'll be discussing the liability of various parties under POPI. I think most attorneys get asked at some point or another, what are the risks and liability to the information officer and the responsible party under the Act. So this presentation is intended as a high-level presentation on these on this aspect of the law. It's not intended as legal advice, and of course, any legal matter is complex and specific regard needs to be had to the law as it relates to the parties in question and the circumstances. So I hope you enjoy this, and thank you for taking the time to watch. Okay, so firstly, it's important to be aware of how the liability may arise in terms of the Act. It may be by way of a civil action, which is instituted in a court with jurisdiction for a breach of the provisions of POPI. And in terms of the wording in the Act, the civil actions are launched against the responsible party. Then there are offences, which are governed by the principles of criminal law, and the Act references the responsible party sometimes as the offending party, and sometimes it references any other party. And there's also reference to the Promotion of Access to Information Act, and in terms of that Act, there are specific references to the information officer as the offending party. Lastly, there are administrative fines which might be handed out by the regulator. These do not involve a criminal record provided that the administrative fine is paid. So first of all, we will address the civil action against the responsible party, which is launched in a court with jurisdiction. And this is regardless of whether there is intention or negligence on the part of the responsible party. And the court may make certain awards if a responsible party is found to have breached one or more of the 8 conditions for lawful processing in the Act. Breaches pertaining to notification of security compromises, duty of confidentiality, provisions pertaining to direct marketing by means of electronic communication, the directories provision and automated decision making, as well as transfers of personal information outside of the Republic, and breaches of the Code of Conduct. So these headings in themselves don't indicate what the actual offences entail. One would have to go through the Act and also obviously understand their own processing in relation to the Act and complying with the Act before understanding really whether there is a risk of breach. Then the award that a court may grant is that of payment of damages as compensation for patrimonial and non-patrimonial loss suffered by a data subject, aggravated damages, interest, as well as costs to be determined by the court. So bear in mind these are awards against the responsible party. And we'll then go on to offences. In terms of the Act, there are specific offences mentioned, and the penalties are twofold. So there are fines or imprisonment for a period not exceeding 12 months or both, or fines or imprisonment for a period not exceeding 10 years or both. So we would start with the first penalty mentioned, that's fines or imprisonment for a period not exceeding 12 months. The first 2 offences pertain to information processing which is subject to prior authorization. So certain types of processing, the responsible party must notify the regulator, and pending an investigation by the regulator or confirmation the regulator will not be investigating the matter further, then the responsible party must cease processing during the time periods mentioned in the Act. And if the responsible party fails to take these 2 actions in terms of section 58.1 and 58.2, then this is an offence as stated in section 59. So any person who contravenes the duty of confidentiality could commit an offence. The obstruction of the execution of a warrant issued in terms of Section 87, any person can commit this offence. The next two offences are in respect of responsible parties, so the responsible party failing to comply with an enforcement notice, or the responsible party in purported compliance with an information notice served in terms of the act makes a statement knowing it to be false, or recklessly makes a statement which is false in a material respect, is guilty of an offence. And then the next offence is one in respect of which any party could be convicted, and this is offences by witnesses in the court proceedings. So as an example, a person who has to appear in court, who summons to appear in court, if they fail to arrive at court with sufficient reason, and this may be found to be an offence of which they could be convicted. The next penalty is a fine or imprisonment for a period not exceeding 10 years or both. So any person who obstructs the regulator, or a person acting on behalf of the regulator in the performance of the regulator's duties, may have committed an offence. A responsible party who fails to comply with an enforcement notice. Any person who, after having been sworn or having sworn in or made an affirmation giving false evidence before the regulator on any matter, or knowing such evidence to be false, or not knowing or believing it to be true, is guilty of an offence. And an unlawful acts by responsible parties in connection with account numbers, or an unlawful act by a third party in relation to account numbers. These are also offences in terms of the Act, which are subject to the above penalty. In terms of the Act, an enforcement committee, in terms of POPIA, may, under Section 93, make a recommendation to the regulator necessary or incidental to any action that should be taken against a responsible party in terms of POPI, an information officer, or head of a private body, as the case may be, in terms of the Promotion of Access to Information Act. Okay, aside from the last slide in relation to Section 93 of POPI and the recommendation that an enforcement committee can make, there was no other reference to the liability of an information officer unless we're referring to those offences by any party, which one would have to be aware of. So direct reference to the information officer and offences that can be committed can be found in the Promotion of Access to Information Act. And these offences, the penalty is a fine or imprisonment for a period not exceeding 2 years. And the first is a person who, with intent to deny a right of access, in terms of that act, destroys, damages, alters a record, conceals a record, or falsifies a record, or makes a false record. The information officer who willfully or in a grossly negligent manner fails to comply with the provisions of Section 14 of POPIA. Those are the provisions pertaining to the manual of a public body. The head of a private body who willfully or in a grossly negligent manner fails to comply with the provisions of Section 51 of POPIA, that is the provisions pertaining to the manual of a private body, and they would be subject to the penalty appearing at the top of the screen. And then an information officer of a public body or a head of a private body who refuses to comply with an enforcement notice under POPIA is subject to a fine or imprisonment for a period not exceeding 3 years, or to both such fine and such imprisonment if convicted of that offence. So that's the end of the slide. It's just intended as a high-level indication of the parties who may be found liable under the Act, and what the different remedies or the awards that may be granted by a civil court, as well as the offences and penalties in respect of criminal matters and administrative actions. So I hope you found that useful, and thank you for taking the time to watch this video.